you want to stand up and fight.
Correct.
That being said, magistrates, for example, whose all the functions that they execute are governed by statute, are considered creatures of statute. Keith Lowenfield, as chief election officer, is not superior to a magistrate. He is a creature of the commission, plain and simple. And he has to follow the dictates of the commission. And his failure to do so ought to be met with sanctions. And sanctions being the watchword today.
Correct. And Commissioner, let me just, sorry to interrupt. Ladies and gentlemen, let me apologize. We have been getting some consistent internet issues. We don't know. We have been auditing our internet, but it's outside of our control. And so our apologies, but do know we are live on YouTube. We are live on Kaieteur News website. You can go there. We are live on the app. We are live on Facebook. So you can get us any which way possible. My apologies, Mr. Commissioner. But can you take us to what is happening? What is the status today, Mr. Commissioner? And is the chairman's hands tied? Mind you, the country would have heard Ms. Kite's explanation to the Chief Justice today.
I started out by saying, that there is nothing that is extant in the proceedings that ties the hand of the commission or the chairman. However, the position, the utterances to the court by Ms. Kite in relation to the position taken by the chairman, in that an undertaken, you remember the chairman is named as a party to these proceedings?
Yes.
The chairman is the convener of the commission. She is the person who has to be there at all times. She summons the meetings. She has a quorum, is not made in her absence. She's the important person in this puzzle. She is perhaps the glue that holds the commission together, if I can use that analogy. That being said, the personal undertaking given by the chairman to the court that she will not proceed or take any steps that will render any decision one way or the other of the court nugatory.
Right.
And she will not take any steps pending the outcome and determination of the proceedings. Like I said, I have my personal views. I don't believe that, and I say this openly, there is no impediment preventing the commission from proceeding.
Right.
But I respect the chairman's position. And I have a little bit of reservation, but I respect it and I support it. It is what it is.
Yes.
And we can proceed therefrom.
Great. So Commissioner, I don't want to question you too much because I appreciate your position as a commissioner who is also, I believe if the commission is in front of the court, then you are as well in front of the court. So I don't want to put you in any unnecessary spots here, but my last question to you, Commissioner, is Guyanese do not share a sentiment that says a few days more. We are more looking that it might be a few weeks more because, whatever decision is made, a party might go to the court of appeal, might appeal this matter, and it might end up at the CCJ again. So whether you can comment or not, I don't know. I just wanted to put that in front of you, sir.
I at some earlier point in this conversation, I said that we're here in excess of 130.
Yes.
Probably we're nearing
135.
135. I remember reading 133. I can't remember how many days ago. None of us, the entire Guyanese electorate, including the rigging cabal, who are desperately trying to thwart the will of the electorate to steal an election and by extension stealing government and a country. I don't think they themselves envisaged that we would be here 135 days later.
Right. Correct. Well, it's getting to the 156 days promised by the CEO.
Well, you'd recall, Yog, that he promised that 156 days when we were a month or two in.
Yes, that was April 8th of April.
8th of April. So that's a month in, a month and a week in. That notwithstanding, I myself have been subject of some amount of abuse today about, what is the commission doing? Right? Now, this is an attempt to pull myself out, extricate myself from the milieu, or being brushed with the general brush that affect. I am but one member of the commission, and the commission operates as a democracy by majority.
Right.
So my desire to have this done on March 4th or 5th, while shared by the general populace, cannot be achieved on my own.
Gotcha.
That being said, I have always placed my reliance and my confidence in the court proceedings and the process of the court, because I'm an officer of the court.
Yes.
I have confidence that the proceedings can be completed in a timely manner. You've heard the Chief Justice today. The Chief Justice complimented everyone for being there, and I was part of those proceedings. You had, I don't know, Marcia was there as well. You had dozens of persons.
Yes.
Right? In fact, counsel for the applicant complained about the number of persons.
Yes.
What counsel for the applicant should have done was complain about the number of times that the electoral process was interrupted by these by these frivolous and vexatious actions.
Correct.
All of which have only served to delay the process and render frustrated the electorate of this country.
Gotcha. Thank you. Thank you for that, Commissioner.
That being said, I am confident in the process that we have executed insofar as it relates to the recount. I am confident that we have followed all the tenets of the law in the crafting, gazetting, execution, and final product of Order 60 of 2020 as amended. And as a consequence, I am hoping that this call for patience to the public out there for a few more days is not a call in vain, and this can be concluded as soon as possible.
Correct. Well, thank you for that, Commissioner. And I must tell you this, at great pains, Mr. Gildarie and yours truly have been on radio every day. And if it's one thing I can tell you we have done, we have stood for and behind the chairman. In fact, Leonard, you would recall last week, somebody called and they were asking about officers of GECOM and the secretariat and the PR officer. And I took pains to explain, and Mr. Gunraj, I would like if you could express our support, even though people are frustrated across this country. A week ago, I expressed great support to your PR officer, to the secretariat. We don't know and we cannot be judgmental about what is happening there. What we can speak about is what we, the people, have seen Mr. Lowenfield do, and we have called that out. What we have seen Mingo do, and we have called that out. But to that point, Commissioner, we'll be grateful if you could kindly give word to the chairman. Our prayers are with her. We stand behind her, and we are certainly awaiting, even though it's taking long, but we certainly are waiting for the end, the light at the end of the tunnel. And our support and prayers would be with you and the other commissioners, as well as, of course, our dear Iron Lady, the chairman of GECOM, Madam Claudette Singh.
Much appreciated, Yog. Much appreciated. And in asking finally and repeating my call for patience in the outcome of this process, I'm tempted to apologize to the nation. But like I said earlier on, that's a personal apology, and I don't speak for anyone when I speak here.
Right.
But before I take your leave, Yog, I understand that we're celebrating a birthday in room 592 today. I understand that it's Leonard's birthday.
Actually, it is not.
I hope that the presents that he got are better than those other persons who are also celebrating their milestone birthdays today.
Actually, I couldn't have called the gentleman's name who was celebrating his birthday today, so I just deflected to Leonard, and he had to take the blame. But his birthday is coming up in December, and he promised a big, big, big party. So I take your point there, Commissioner, even though I know you are being as well. You're being a little mischievous here as well. Leonard, you got to take it, my brother. 75 years old, you are my friend, and what a party you had today of morose faces.
Yes, it was. I remember, and I must say in part in the Sase saying goodbye. There was a time that I interviewed the good president, and I made a mistake and says, I think it was 76 years old. He said, "Who's 76? Who's 76?" So I leave it as that. I thank you for the birthday greetings. It's a little early, but it is what it is.
And if you don't deliver that party as planned, Leonard, you will certainly be met with sanctions.
Yes.
Ladies and gentlemen, Yog, thank you for having me, and have a good night all.
Thank you, Commissioner Sase Gunraj. Ladies and gentlemen, that has been Commissioner Sase Gunraj giving us an update as a commissioner. What is the perspective from the seat that he holds there? And now we want to turn to our legal experts in the room. Ladies and gentlemen, let me introduce to you Miss Marcia Nadir Sharma, and many of you would have known her. I'm not going to get into the politics behind the scene, but she is, I believe, are you on the list, Ms. Sharma?
Okay. No, I'm not.
Okay, so Ms. Marcia Nadir Sharma she has worked in public service, and she has been a practicing attorney at law for many, many, many years. One of the things that you would admire about Marcia is that she has been outspoken regardless of how the politics is played out. In other words, she's called it how she would have seen it, regardless of whether it meant disagreeing with her boss or not. Marcia would have also operated under some extremely challenging circumstances. And so she comes to you as if like you squeeze a bean and it pops out. She comes to you having faced a lot of pressures in her young life. And this is a young lady, I believe, that as Guyanese, we must be proud of for the positions she has taken. Marcia, welcome to room 592 once again.
Thank you for that, thank you.
And ladies and gentlemen, let me also welcome formally Mr. Siand. That name, I have to get it right. But, if you want a young attorney, ladies and gentlemen, that is passionate, more passionate about the law, look at people who love the law, you're looking at this young man here. And Mr. Siand Dhurjon is probably the most successful young attorney we have and that we can be proud of here. He is under 30 years old. I don't know. Please don't ask me whether he is available. You will have to ask him that yourself. He is under 30 years old. He has had his own small law firm which has been engaged in a wide range of legal jurisprudential matters across the plethora of legalese, as we would say in Guyana. He has looked across many diverse fields, he and his firm. Mind you, he's an independent thinker. And I wish to welcome him in room 592 by saying that Mr. Siand Dhurjon is an independent thinker who joins us tonight as a man who voted for the APNU-AFC at the last elections, but comes here with a little bit of or a great bit of disappointment, disgruntled with what he's seeing. This is not a Guyana he wants and he would have voted for. Ladies and gentlemen, however, tonight we are going to look at Mr. Siand Dhurjon, not necessarily to talk politics, but to express, let us dissect the law, let us dissect what is in front of the courts, let us dissect for the sake of our brothers and sisters Guyanese who are not legal minds, to understand what is happening here. So Siand, welcome to room 592, my brother.
Thank you, Yo. Thank you.
Ladies and gentlemen, as we get on with our discussion tonight, I would like to probably go to Marcia first. Marcia, we have had a situation here which, as you would have known, has reached to the stage after a number of narratives. So on day one, it was using bloated numbers. Mr. Mingo resurrected the dead, created the invisible, you name it, he did it. And he released some numbers. Then, Marcia, APNU-AFC said, let's recount, because the whole world turned out against them. Then APNU-AFC said every vote must count. Then they said every valid vote must count. Then they said fraud is fraud. And after saying fraud is fraud, they have now gone back to getting married to fraud, because they have gone back to using Mingo's bloated numbers. Ladies and gentlemen, Mingo added 15 to 20,000 votes that did not exist in the boxes on March 2nd and did not exist in the boxes during the recount. Marcia, as a legal mind, how can you ever connect those dots for us if I were to ask you to take the position of an APNU-AFC lawyer? You have to represent your lawyer.
Wow,
you have to
well.
represent your client.
That is an extremely difficult position to put me in. But no, I can appreciate it though, because let's be frank, the APNU-AFC has it's a significant support base that actually believes the message that is spewed on a daily basis, which says things, for example, like, as you rightly articulated, we won. We don't need to prove our SOPs. The PVP was crazy for producing its PVPs. It went outside of the boundaries of GECOM and by publishing its. So that's absolutely nonsense. I can understand them saying that in the first place. And then, Mingo is the right person. He's the legal statutory person to make the declaration, or for Region 4, where all the trouble happened. And then when that, let's be frank, they were blindsided. The APNU supporter, or as an advocate for the APNU, I would have been blown out of my comfort zone when I would have been in court and making representation that the commission should not be answerable to anybody, that Mr. Mingo's figures I would have been sitting in court on the 14th of March saying, on behalf of the APNU and the commission and Yulita Moore and and in the Claremont Mingo case, that I, as a counsel for the APNU, I'm saying to you, Your Honor, Chief Justice, that there is no way you can hear these matters to be told in court, the rug being pulled out of me, that my leader, the head of my party list, has just consented to a recount. Okay, so I'm there making these representations, exposing myself as legal counsel, and there you have the head of the list making the recount public through CARICOM. Having completed the recount, or in the course of the recount, as legal counsel, I probably would have advised that, look, we need to start making some issues with regards to what we might deem anomalies, because one of the things I would not want to do as an APNU lawyer is to say to my party, we should allow this recount to be completed, because ultimately I know from the SOPs that we did not win. Okay, so right. I would therefore be, like they have done, advising them to do what they need to do. But you see, the problem is this. At some point in time, whether as a lawyer or just a regular elector or just somebody with civic responsibility, moral compass comes into play. And having a political maturity to say to my advisors, to my clients that, look, at some point in time, you need to stop this, because what we are doing here is not only wasting the court's time and wasting the goodwill that we have garnered for the last, well, you got to say from 2011, because technically speaking, from 2011, that train would have left the station, resulting in a 20 win. Okay, So that little goodwill that we have managed to garner, and then having not done what we promised in our manifesto in 2015, we need to pedal back a bit and look at what the damage would be. But you know what? That has not happened. That leadership has not happened. And unfortunately, I would never, well, fortunately for me, I would never take a case where I have to go and work with somebody that my moral compass will be on the fly.
But exactly, and thank you for raising that, because at the end of the day, Marcia, and you know, Siand, I'm coming to you in a second. Marcia, at the end of the day, Guyanese people have heard this thing over and over. It is not illegal. It is not illegal. So you know, the whole course of natural justice seems to be kicked out because the law doesn't say something explicitly, so people write on it. Is that how lawyers think?
Not because the law doesn't say something is explicitly, sorry, let me rephrase that. You cannot imply a meaning into the law. The people who draft, the parliamentarians who sit and draft those laws, constitution framers, whatever they put in there is what they mean. And what there's no interpreting it. If they wanted to say that the sky is pink, they would have said so in the law. Right. They would not have left it to your interpretation. So the law is what it is. What you see there in black and white is what is the intention of the law, and you have to comply with it. And the recount, well, and I say this in the context of course, the election laws, but it applies to any law.
Correct. So, Siand, I want to come to you a little bit from a more technical perspective in terms of one of the petitions, or one of the things that the applicant is begging, pleading at the court for, is that Section 22 of the elections law should be kicked aside, should be declared as inimical to the Constitution. And is it, am I right, sir, to say that the aim of that is to then say the entire Order 60 was null and void and stop? Can the law be applied? My second question, can that law be applied retrospectively, sir? Over to you.
Well, in law, there's something called subsidiary legislation. Normally, with ordinary legislation, Parliament has to vote on it. You have to convene a Parliament. They vote on a bill to make it into law, right? This thing must be a crime, or this must be a tax, or that must be possible, or that must be prohibited. But ever so often, Parliament passes a law that says a minister, for example, a chairwoman, for example, a commission, GECOM, for example, has the power to pass law within these narrow confines, right? So what we had passed in the year 2000 was the Election Laws Amendment Act, which provided in Section 22 a special regime, a special unique power that GECOM has now to remove difficulties by passing orders. Now, an order is one such type of subsidiary legislation. What Parliament did in the year 2000 was they gave the any chairman, any commission, a blank check. But not just any blank check, a blank check within certain narrow confines that they can cure or remove difficulties. And the rationale for that, Yog, is very simple. Elections is serious business. Credibility has to be ensured. Finality has to be ensured. The process must be expedient. All right? Right. And yes, what they're trying to do, the application filed by Messenger Jones, who, by the way, happens to be an APNU counting and polling agent in Tocqueville. I don't know if people know that, but in her affidavit at paragraph 60, she said, no, at paragraph 11, she said, I am a community organizer with a strong interest in politics. Well, she omitted to mention that she was a polling agent at Tocqueville. She signed the statement of poll at Tocqueville. Wow. You understand? As the PA/CA. as the polling agent slash counting agent.
Counting agent.
So I could send you the copy of the SOP.
Thank you. Yeah.
But let me move away from that. What she has filed is an incredibly ambitious fixed date application, claiming some 27 orders. She's claiming setting aside the legislation, setting aside the recount process, reinstating fraudulent results that have been internationally accepted to be fraudulent, preventing, if you look at one of the most controversial orders that she is seeking is that Order 25. And it says she is seeking an order restraining from taking the oath of office as president any person identified other than the president, other than the candidate in the list which Lowenfield is showing. So she is trying to get the court to restrain GECOM from declaring anyone to be the winner other than Granger. Mm-hmm. This is the most ambitious application I have ever seen being made in a court for a lot of reasons. But back to your specific question, the recount stands atop Section 22, simply because that is the regime under which they acted. They put together that order. Now, it would be a hell of a tough fight for her to convince the court that Section 22 is unlawful because of the reasons I just said. Because Parliament in advance in the year 2000 said any commission hereinafter can pass such a law or make such an order to remove such difficulties. And I dare say, if ever there was a moment for the activation of Section 22, it was this year where they met the moment and they passed the recount order.
Right. And Siand, if I may just ask for a little bit of definition there too, just for our viewers and listeners, because one of our viewers, I think quite rightly pointed out, and thanks Ramesh, he pointed this out, that one of the important factors of Section 22, it has to be recognized that at the time of election, Parliament does not exist. There's no legislative body, and thus this is a necessity. Over back to you, Siand.
Parliament in its wisdom, the drafters in their wisdom, would have envisaged all of that at that time in the year 2000. Right. You understand? You hear that we were exiting as a nation in the year 2000 in preparation for the next election. So it comes as no surprise that that order was made. But the other thing is, the CCJ actually made a tacit or a veiled reference to Order 22 in their decision. They did not Order 22, Section 22. They did not spell it out, but they did very well mention that that there was a removal of difficulties with the recount order.
Right.
You understand?
Right. But Yo, yes, if I can add to what Siand is saying, because what he is saying, we need to also now add context. And I think it's very important that your viewers understand the context. The difficulties in this particular situation was the fact that the APNU-AFC plus its appointed commissioners at GECOM objected to CARICOM coming in and supervising and conducting the recount. Let us not forget the factual context within which this Order 60 came about. So what ended up happening was after His Excellency, after President Granger would have said, I agree to this recount, within 24 hours of being blindsided, the narrative out of the camp was that, wait. The Representation of the People's Act does not allow for anybody other than GECOM to carry out a recount. And so CARICOM's agreement between Dr. Jagdeo and the president can't be materialized, cannot be put into effect. And that is why Section 22 was employed, to remove that difficulty of CARICOM not being able to come in and provide that neutral balance between the obvious growing conflict of PVP saying they haven't won and APNU-AFC saying they have won on Domingo. So I think that context is very important to remember.
Yes, thank you for that. And I want to come back to you both with this question. let us just say that the court in its wisdom decide to slice and dice these applications, petitions up. And let us just say there is a likelihood that one of the courts, I'm not saying it's the immediate one, but one of the courts may see that, okay, you know what, Section 22 is in bad faith. Marcia, can that being in bad faith affect the order, affect something that went and was approved by the CCJ? In other words, if the court was to strike it down, can it do so retrospectively to when the recount happened?
I wouldn't want to because I am on record, I wouldn't want to give an opinion as to where the court will rule. But I will say this. The CCJ in its last decision made it pellucidly clear that the only result available for which a declaration can be made is the recount process. Pellucidly clear. There's no ambiguity, there's no uncertainty, and the whole issue of whether these previous declarations made prior to the recount are valid was dealt with by the chairwoman in her decision. And let us not forget, the CCJ recognizes the chairwoman's erudite position as it relates to GECOM's inability to disenfranchise or to mysteriously and arbitrarily disappear 115,000 votes.
Correct. Okay. Thank you. So Siand, yes, I wanna ask your opinion on the same matter. You may not be so constrained, and also address along the same line whether the CCJ statement is now material or not.
Oh, the CCJ statement is incredibly relevant right now. In fact, that's why today, if you were listening to Her Honor, the Chief Justice George, she said two of the main issues that would adhere throughout these proceedings. Or let me don't misquote her, but she said two very important things that arise here are jurisdiction, one, and two, res judicata. Right. Now, what res judicata simply means is Latin for a matter already decided.
Yes.
Yes. This is the fourth tranche of proceedings. First, we had Holadar. Then we had Yulita Moore. Yeah. Then we had Leslyn David. Now we have Jones. In the three previous applications, the judgments and the decisions, the rulings in those three previous decisions overlap with issues that now Ms. Jones is asking the court to relitigate here now and again. Right? The CCJ was very clear in the way they endorsed, in the way they impliedly approved of everything in the recount, the recount regime, right? But back to your earlier question, you raised a very, very interesting legal question, and it took me a moment to think of it. Let us say by some way, Order 22 Section 22, is found to be unlawful. There's something in law known as mutatis mutandis. In our Representation of People Act, there are provisions which relate to a recount. Yeah?
Yes.
It is possible that they can say that the recount that we did recently was not unlawful because it still could have fit, although not perfectly into the Roper regime, but it could have substantially fit into the Roper regime, and it ought not be invalidated. But that's a very strange hypothetical question. We don't expect that to happen at all.
Marcia.
But you know, Siand, I mean, having been at the recount, being in one of the workstations, I gotta tell you guys that what actually transpired in the actual recount workstations is pretty much what happens at the polling station election night. So there was no, even though the order 60 provided a certain detail, context, the reason it did so was because Representation of the People's Act Section 88 did not specifically outline the process. Yes, Roper says that if you're going to have a recount, you will apply a particular regime. But again, we must remember that the government appointed commissioners insisted that the order cater for essentially an audit. It was on their insistence that things like the insertion of the word credible be placed in the order. It was on their insistence that, and then this is information that has been in the public domain. I mean, for one, Mr. Alexander would come out and have his little briefings, and he would say that, you know, this is my interpretation. It mustn't be done like this. You know, and again, we can't look at these things in isolation of understanding the facts. And so, having sat through the recount process, anybody who worked in a polling station on March 2nd will attest that it was the exact same process, just a little slower.
Right. So let me ask you guys another hypothetical question. It's obvious that APNU-AFC at this stage wishes that the recount never took place. They want to go back to using the SOPs, but they want to go back not to SOPs, sorry, they want to go back to whatever it was that Mingo and the rest of the ROs declared. They want to go back to the declaration. Will it, Siand, you first, should that request cause a necessity or a call for the release of SOPs? Will there be any directives that say, okay, you want to go back to this, it would mean releasing the SOPs from GECOM?
Well, I don't think the court will concern itself too much with the SOPs. We all know what the SOPs say. And that hasn't really been disputed in any real substantial fashion. But I don't see a difficulty where the court, you see, that's water under the bridge. That ship has sailed where we could use Mingo's declaration. Now, that was exactly what caused the furor and the uproar and the outrage and caused us to have to embark on over a month of a recount exercise. So that is water under the bridge. That even the government's own commissioners, Vincent Alexander, has said that no longer is in the equation.
That's true.
The fraudulent thing is no longer in the equation. We are now on a new exercise. What was the point of it all? What was the point of the month-and-a-half recount process?
Correct. Well, Siand, I'll remind viewers and listeners that Alexander was in room 592, Leonard, and the gentleman, to his credit, he said that he wished, or I forget the word he used, but he basically said that a court should have thrown those declarations away, should have been put out of the way before something else is done. And the fact that it hasn't been done meant something to him. Obviously, we are now seeing that being played, Marcia.
Well, I gotta say, if you look at the reliefs being sought in the present case, and you compare it with, say, the reliefs being sought in the Ulita Moore matter, all of those issues there are many of them that are similar, including the fact that they want to be able to use the Mingo recount. The Mingo figures, the declarations. But I agree with Siand that is water under the bridge. That boat done gone way, way too far to roll it back in. And there was no need for a court to make that decision because GECOM is an independent body.
But Marcia,
GECOM already made that decision.
Let me push back at you both. Hold on. The head of state, the president, 2 days ago, made a statement in open, in public, saying that, or pointing to flaws, or pointing that the CCJ decision allowed for this recount to be thrown away and to go backwards, and the fight is not over. Is Mr. Granger engaged in public mischief? Is he so badly misled that as a president he would say so to this country? And Marcia, as an attorney at law, this is the president of the country. What position does it leave us in then?
It's a complete misrepresentation of what the CCJ said. The CCJ had never had before it any question as to the validity of the recount order. That was never an issue for it to decide upon. That's the first point. Secondly, the Justice Saunders went to great painstaking effort to outline the recount procedure and the process, and to complement its transparency and credibility aspect. He didn't use the word credibility, but he, in essence, said that. Okay?
Mm-hmm.
And what he said, and we have to be, and when we're going to make representations to our supporters, or to make statements, we need to be clear. The court said the notion, the idea that this order, and this notion, remember, is the argument of Ms. David, that this order created a whole new electoral regime that took representation of the People Act and sent it flying on a vacation, and that only this order determines the outcome of the election. That was the notion before the court. And the court said the notion that that can happen is absolutely constitutionally unacceptable. It never said that Order 60, the instrument Order 60, facilitating the recount, was invalid. So it's a colossal misrepresentation.
Thank you. Siand, we know that in Guyana, the president, unlike many jurisdictions, is in an elevated position where legal actions and so forth are concerned. Sir, could you share with us your thoughts? Mr. Granger has been making statements that can be deemed to be misleading people, because at the end of the day, sir, the supporters that he has said that to will go home and believe this is the word. Siand, how does it leave us as a people of this country where the law is concerned then?
You're asking me a good question, yo, but let me say something. I don't believe most APNU supporters are that stupid. I think they just have a few handful of people who will believe these things baselessly. The lawyers for the coalition have been touting paragraph 52 of the CCJ judgment. They have been taking it way out of context. The CCJ at that time, they were commenting on the Court of Appeal's flawed understanding. They were saying that the Court of Appeal had misread a word into the Constitution because they had used Article 60 to influence them to insert the word validity into the Constitution. And the CCJ said in such a hypothetical situation, that could never be done because Article 60 is, at best, is ordinary legislation. And the Constitution is the Constitution. So you can't use your subsidiary legislation or ordinary legislation or anything to interpret the Constitution. The Constitution is a self-fulfilling, self-affirming document, and its meaning and intent is clear. Right. What the judges were saying, they said, with respect, the notion that Order 60 could either impact interpretation of the Constitution or create a new regime, election regime, at variance with the plain words of the Constitution is constitutionally unacceptable. So what they're basically saying is that if you think Order 60 could interpret the Constitution or create a new regime that is different from what the Constitution provides, which it did not, then that would be outrageous.
And Yogi, that's not what we're talking about. And Yogi, if I may ask you three councils, including you, Yog, do you believe that everything that is happening here, including sanctions, and I see a statement now coming out from the Brazilian government about this entire elections, and they're calling in for a declaration to be made according to the recount. Do you likely to see that there's going to be a buckling of the coalition, maybe, and this matter is not going to advance to the Court of Appeal and maybe to the Caribbean Court of Justice?
I personally am not applying a legal mind. I personally don't see any buckling happening because I think it's a case where the APNU-AFC coalition has put itself out on a limb and they're now all in and there's no pedaling back. There's, at this point with visas, for example, being revoked, it's just a stepping stone to something greater happening. And strategically, it would appear weak to go back to your supporters, which you could have done 3-4 weeks ago and say that, look, we have lost these elections, let's buckle down and gear up for the next 5 years. And they didn't do that. I don't foresee them doing it anytime soon either.
The letter of the day is V. V is for visa.
Well, you might very well say somebody or see somebody. I see somebody making a little post here whether they should be going to court to question whether it's an invalid visa or it's an unqualified visa. I'm not sure. But yo, this is interesting because if you see the Venezuela, somebody is a country that is very very close to us. That is saying that 4 months after the election, the Brazilian government considers that delaying the conclusion of the electoral process poses a serious threat to stability in Guyana and a departure from the democratic commitments that the country must observe in the regional and hemispheric context. And they close off by saying the Brazilian government calls on Guyana and associated state of Mercosur to remain among the South American nations committed to the highest democratic principles. I know that we have diverted a little, but that's to show that there's a lot of pressure piling, and that's why I saw this morning in the court the judges really put down her foot in, when there was a clashing between a couple of councils. She said, "This is my court," and then I think also when the question came of the AG and his counsel, I think it was Maxwell or somebody there, trying to make a move towards a motion to have the proceedings stayed. She says, no, we're not going to tolerate that at this moment.
Right.
Or it was said at that point in time.
I want to quickly, if you don't mind, lady and gentlemen, I want to quickly come back to one of the points in law again. Siand, you first. This case in front of the court, it has the potential of ending up, in my mind, correct me if I'm wrong, it has the potential of ending up at the CCJ. If it does so, isn't it like a vicious circle? Ultimately, it's a CCJ thing ending up back at the CCJ. Oh, whether the CCJ is final jurisdiction then?
Well, the funny thing, Yob, is that if this does reach full circle, and if it does go to the CCJ, it is no uncertainty that the CCJ will be scathingly condemn this application. It does not help that it was the same attorney that the last matter that went to the CCJ, and now they are misquoting in effect the CCJ's judgment. Yes. But yes, that Justice George has taken a very strong position, an extremely admirable position, that by 11 tonight, the applicant submissions have to be in. By 11 tomorrow night, the response have to be in. You understand? So he's fast-tracking the process. It is not that she is sacrificing justice at the altar of expediency. She's not doing that. She will take her time to rule, hopefully by Sunday. You understand?
And I want to come back at you. I'm sorry, Marcia. I know you are a face in the court there, so I respectfully don't want to ask you some of these things. But here is another question we have for you then. I would admit, I admire the way Madam Roxanne George has dealt with all the election matters in front of her. I remember with the Mingo with the 84, Section 84-2 matter, she took pains, slapped them on the wrist when they needed it to say, I am not going to go down the road of elections petition. Walk the thin line, walk the fine. However, Siand, is there a likelihood that this matter will not end up at the Court of Appeal?
I strongly believe the fact that they have launched this application in the first place, and from if the recent pronouncements by the president are anything to go by, it seems that they have no holds barred, and they will go full 100. But it has to end at some point, yo. It has to end at some point. And speaking of the Chief Justice, she is a judge whose integrity has no equal in the world of the judiciary. When she was a puisne judge, I personally went into her office and asked her to admit me to the bar. I wanted her to be the person to do it. I never knew in years to come she would be elevated. But yeah, we are confident. This is a very frivolous application, yo. I wanna show you something else. I don't see the legal commentators or the attorneys raising this point. Sase said that the CEO is a creature of the robust statute. The Constitution, as you said, did introduce him first into the scheme of things. But what's important is that the level of entrenchment, the security of tenure, and the requirements, the qualifications of the chairman are constitutional.
Of course.
A porter could be appointed as the CEO. It is the chairwoman who is the technocrat, who is the technical person in all of this. You see?
Well said. Yeah, well said. Well said.
She has to be a judge or somebody, a fit and proper person. She is appointed from a list submitted by the opposition, by the president. You understand? The CEO is just a man that the commission can decide tomorrow to appoint or to disappoint.
Right. Right. So thank you for that. That is well said. And indeed, I think up to this point, and this is not being critical of the chairman at all, up to this point, I believe the chairman's finest moment has been that June 16th or 17th release she made, which was absolutely clear and absolutely spot on as to what she sees her role and the role of GECOM to be. Marcia, I would ask you to put on a political cap. Given what Siand just said, obviously this case will fail at the ultimate court in our view, not necessarily your view, in our view. Therefore, there is a political play behind the scene. There has to be something in this delay that will mean something to APNU-AFC. What is it in your mind, if you can point to something that we are not seeing?
I don't think the question is political. I think that it's more, the longer we delay the swearing in or the declaration and swearing in of Dr. Irfan Ali, the more we punish the PPPC and its supporters. And I know that sounds crass, but there is no logical explanation for 4 actions, one after the other, to adjudicate in the same matter, and consistent with the flip-flopping and the inconsistencies of statements. Politically, knowing that you have threats of sanctions, knowing that the first step to those sanctions have started, and you're still holding out that we are not interfering with the GECOM process. We've been sitting aside and watching from the sidelines and being very pious about it, but yet going on television and around the world saying, oh, no, we've won these elections. It just simply means that, in my mind, politically, APNU-AFC wanted to get a full 5 years. The no confidence motion curtailed their 5 years in government. And their hope is that, look, the whole of 2020 can pass and I will still achieve my 5 years at a minimum. But if I have to lose, and the court says I lose, and I have to relinquish control of the public purse, it will be on my terms. And that's all. It's really just schoolyard bullyism at its worst, because this is not something that affects just the leaderships of these political parties. This is something that affects the entire country at a global scale.
Right, but let's assess that. And Siand, your comments here would be most welcome. Let's assess that, Marcia, because here is what. The 5 years are gone with in May this year, right? And you are soon going. The way we are going is going to be 6 years. I rather suspect this drama is not over by any long shot. Mr. Lowenfield still has the ability to frustrate the commission. And if he's going to be replaced, his replacement still has the ability to frustrate the commission. It is a vicious circle that can go on and on and on. Meanwhile, Siand, the country is literally bleeding.
Burning.
We have a situation, ladies and gentlemen, where today, with due respect to the gentleman, is his birthday and he has every right to celebrate his birthday. But there are people in this country that doesn't have a meal to eat. Their children, this what get me going. There are children in this country that has no ability, don't know where mommy and daddy is going to find the next meal from. So, Siand, as a young man, putting your legal cap aside, sir, where do we go and how do we talk to our people now that we can see the light at the end of the tunnel? And the final question for you both, the longer this protracts, the more it's ringing the death knell of a couple political parties, including the PNC.
I am unhappy with the way the chairperson has been doing things. Somebody has to say it. I am unhappy with the way that when the CEO is given something to do, he is given at least 24 hours to add up a table of 10 numbers or so, and to make divisions or allocations about seatings, which already ought to have been done long in advance. I am upset that every time court proceedings are filed, in spite of no injunctions being issued, the chairperson folds her hands and fumbles. And now, as the nation burns, she does not act again. I am upset that today an undertaking was given based on a most frivolous application. I'm upset about these things as a young man, not as a legal mind. I'm upset about these things.
Gotcha. And Marcia, in terms of the political spin again, I would want to disagree with you, my good lady. I would want to disagree with you from the following perspective. Some politicians are absolutely myopic when it comes to the good of the people. Mm-hmm. And every passing day, we are having certain trades taking place in this country. I am interested in knowing what's happening to our continued production of gold, for example. Where is it going? What are the disclosures being made at the gold board and stuff? You see where I'm going to. And also, Marcia, I cannot ignore the fact of your previous engagement of having been one of the officers within a particular state enterprise that is NISIL. And so what comes through your mind when you are seeing the disposal of state assets after the March elections, ma'am?
Well, from my own experience, and again from my NISIL experience, when we were in election mode, we did not have instances of these kinds of mass allocation of properties and selling off, despite how political and attempts were made by the APNU-AFC government campaigning at the time to say that we did. And it's legally, there's serious grounds for questioning those because, again, the whole notion of caretaker government and the extent and the span of their powers during that interim period raises questions as to whether we can be signing $14 billion contracts, selling out lands. Certain entities have certain benefits of being a private company or a corporation. And so those companies and areas might prove a little bit more challenging to investigate and otherwise delve into their actions. But from a central government perspective, it should not be happening.
And if I may, people have been asking councils whether somebody could sue GECOM and or any other parties, and I would like to hear your thoughts on that after this is all over for stress, among other things.
And Siand, if you can also put this in your contemplation, can any of the stakeholders or should any of the stakeholders consider filing a petition at the court to have the court instruct Mr. Lowenfield as to what his duties are in a similar vein as they had to instruct Mingo what 84.2 means?
Very good.
Absolutely. Absolutely. It would almost be like an order to enforce a judgment of the CCJ. Yes, for him to do what he is lawfully supposed to do, given the CCJ's recent ruling. And this would not be an election petition issue. This is a process issue where an office holder, a statutory office holder, is not following the clear letter of the law. Chief Justice George did it in the Holidar case where she compelled Mingo, a statutory officer, to follow the strict letter of the clear statute, in that he had to do the tabulation transparently. Mm-hmm. Right? So I think this should have been done long ago.
Right, right. I thought so. And Marcia,
I would respectfully though disagree. I would actually respectfully disagree, not because we can't do it, but we would be guilty of doing the very same thing that APNU-AFC is doing. Do you really think that Mr. Lowenfield, having disregarded everything, every instruction and directive given to him now, including previous court judgments, will listen to a judgment from a court compelling him to act? I mean, Marcia, the man has no fear of going to jail for contempt. The fact that he has private criminal charges against him and he still hasn't presented himself to stand and answer to those charges tells me that it didn't matter what court tells him what, he will ignore. So the best course of action in this situation at hand is really and truly for the commission to sit down and say, listen, this man has been insubordinate. This man has repeatedly ignored our instructions. We have elections to complete, and if he cannot perform the functions, we either suspend him or we remove him. Then you face
right, Marcia, here is where I would want to take the side of Counsel Siand Dhurjon. Here is why. At this stage in my mind, as a citizen of this country, that Mr. Keith Lowenfield has decided to burn my ballot. I don't know whether my ballot has been counted or not. Mr. Keith Lowenfield, and I'll have you know that in our daytime program, I have addressed him fondly as Mr. Keith Lowenfield. But Mr. Lowenfield has, Siand, if he is fired by GECOM, that's it. He's fired by GECOM. But if he is fired and in that process, he also contravenes a standing direct order of a court, isn't it then more weighty?
Yes, he can be jailed for willfully disobedience. And anything he does in contravention of the court order is a nullity.
Thank you for that point. Yeah, because I didn't think of that. Marcia,
but he doesn't care.
No, but that's fine. But my point is that the penalties that can be meted out would be even more severe.
Can't be any more severe than life imprisonment for fraud.
So tell us how he would face life imprisonment for fraud under the current circumstances.
No, the private criminal charges that have been brought against him for breach of public trust carries up to a life imprisonment sentence if he's found guilty.
Okay.
So, I mean, I'm saying that if that threat of life imprisonment does not force him or force him to do what is right, even if the court, I mean, I'm not disagreeing that the formula.
Let me rebut.
I'm not disagreeing with Siand's formula. I'm just saying that the creature that is Mr. Lowenfield and his conduct in the past 4 months suggests that it wouldn't matter what the court says to him. He will do as he pleases, irrespective of what those actions are, which is a complete perversion of the law.
That's right. I get your point. Let me rebut quickly as follows as well. Now, Mr. Lowenfield is there, and he's obviously going to do what he wants to do. But Marcia, to the point of having an order, isn't it therefore allowing this man to get away with it? Because here's what we have presumed that Mr. Lowenfield's interest, his only interest, is to have David Granger sworn in. That's all he wants, because that's the only way he'll get a presidential pardon. Over to you too.
Well, I think that's exactly what he's counting on. He's counting that the criminal matters won't really matter, because it will be the correct government, according to him, who can take steps to dismiss or withdraw or pardon the matter. But I want to raise something else. I think now is the time for Article 161A, which speaks to removal of any officer that the commission appoints. Yes? Okay. And the funny thing is, I don't know if other people realize this, but this constitution, the fact that it's 161A, the fact that there's a letter in there, means that it was a later addition to the constitution. It wasn't part of the original constitution. They added it in, right? And in the year 2000, the same year that the election amendment laws were added to remove any difficulties and to allow the commission to make an order, there was an amendment to the constitution in April 2000. Yes? that provided for the commission to have full control, power to remove and exercise disciplinary control over all of their staff. So it comes as no surprise that in the year 2000, I rather suspect that the Parliament and the Attorney General's chambers were in overdrive reforming the electoral laws to provide GECOM provide GECOM with the tools to do their job efficiently.
Gotcha.
With a full consultation process.
Right. But the aim, I think, to Siand's point and to your point, Marcia, for the viewer's sake, the aim there was to create an empowered GECOM to get what it has to get done and get it done expeditiously. Nobody thought of APNU-AFC, PNCB doing what they did. And at this moment, let me just remind viewers and listeners, I know we have viewers all the way from Pomeroon, Cariveton, Oriala, that is joining us on air by radio as well. So it's good to have you all here. Marcia and Siand, another point that may be sounding like a long shot, but let me state it anyhow. There is a likelihood that even if the chairman were to declare Irfan Ali as a president, the likelihood might be that Granger is going to say, well, he don't agree that these elections were fair and he's not going to give up power. Of course, we all know that it's going to earn the ire of the international community and everything else that everybody has been bemoaning. My question to you, sir, the UN Charter on rights of voting, rights of the electorate, will that be enough for international bodies to then take a government like this to the international court, criminal court?
Well, I haven't read the charter, Yo, but I'm sure that there must be international recourse. But the chief weapon in our arsenal back then would be the international community. And such a situation where a man unlawfully seizes the presidency is a situation that warrants boots on the ground.
If
all kinds of things we are liable to suffering if that happens.
That's right.
If I can also add to what Siand is saying, there are already agreements that Guyana has signed on to in relation to even in the OAS instance, where such not just court action at the International Court of Justice, but other types of actions can be taken, and so we are not without recourse. Let's put it that way. But in any event, irrespective of what happens with this case, and hopefully with declaration and the swearing in of Dr. Ali, you are going to see a continuation of the court matters because we're going to have a petition. That's neither here nor there.
Let me ask you this. Excellent point, Marcia. And this was another question. I'm glad you raised that. This is another question I have for you both. If APNU-AFC has now gone to the courts and said, don't bother with this recount, it means don't bother with anything the recount found. Where then, how are they going to come up with an elections petition matter after these elections? Because they have negated by a court action their own stuff.
The elections petition wouldn't have a prospect of success. You see, those petitions are legendary in law for having an extremely high threshold that the petitioner has to meet. It is not just to say what Harman has said that, oh, there are 100 and something dead people or
200,
whatever, 200, whatever. You have to show that the irregularities were such a scale to cause the results of the election to be completely different, to cause the
significantly different,
to cause the allocation of seats to be different. You understand? It's an incredibly high threshold. I don't know if it will appear very well.
All right. So I guess we can continue this conversation because we are at the top of our hour. Who would know that we're already at our program timing, and Kaieteur Radio would have had other programs lined up to take over here. So Marcia, let me thank you for coming. I believe our conversation has a lot more that we can develop into, and I'd like to welcome both of you to return, not necessarily together, but on your own right in the short, near future. It's been a pleasure to have you here, Marcia. It's been a pleasure to have you here, Siand, Dhurjon. And Marcia, your closing comments, 30 seconds, please.
My hope is for, and my message to all Guyanese, again, we've been patient. I know 135 days seems like a long time, but be patient, be resilient, be resolute. We have not stopped the fight. We're not going to lie down and roll over. We've waited this long. We can wait a little longer. Bear with us. And that's the most I can at this point. And maybe appeal to the APNU-AFC camp to please concede and think about what you are doing to the country, and let us put this behind us and move forward.
Thank you. Siand, your closing comments. I know you lawyers get used to closing comments. This is why I'm giving you your closing comments. Siand, thank you so much, and your closing comments, please.
Thanks, Yo. The pleasure has been all mine. There is such a thing as intellectual dishonesty. Shakespeare wrote in Hamlet, "To thine own self be true." After that, you can't be untrue to any other man. We have to think about what kind of world we will wake up to after there is a lawful declaration or an unlawful declaration. We have to decide whether the next installed government will rule over a wasteland or a peaceful, harmonious country. We have to realize that our children have to go to the same schools, irrespective of whatever political party we.
That's right. That's right. Well, thank you so much for that, Siand. And ladies and gentlemen, let me say on your behalf of special thanks to both attorneys at law in room 592 tonight, Miss Marcia, Nadir, Sharma, and Mr. Siand Dhurjon, for joining us here. And it has been quite a stimulating discussion. And I want them both to know that we have received a lot of inbox messages. We have received a lot of kudos for you both. And I think, a lot of people have appreciated that Siand, especially from your perspective, a young man in terms of age, not necessarily experience and knowledge, has stepped forward. And we look forward to future engagements with you and with yourself too, Marcia. Hopefully we can be in touch. And thank you so very much for being here. Ladies and gentlemen, let me thank you all for joining us tonight. It's been a pleasure to have you in room 592 again. I want to let you know tomorrow night, we will have a diaspora night. We're going to be bringing in some of the members of the diaspora, young and not so young persons, to talk with us in room 592. So look forward for our discussion tomorrow. And Leonard, we are in your good hands at 1:30 tomorrow, aren't we?
Yes, we are. And of course, we're going to be looking back at everything, including the sanctions, because by tomorrow, 11 o'clock, we're supposed to have a press conference with the U.S. Embassy and have a little more clarity on that. Among other things, discuss the Brazil entry into the whole fray. So many things to discuss tomorrow.
Great. Thank you. And ladies and gentlemen, indeed, we'll be discussing, and we're hoping to have an expert join us, hopefully either over the weekend or early next week, to talk about international sanctions and what they mean. So we will be certainly in touch with you on our social media pages and via Kaieteur News and Kaieteur Radio. Let me thank you all for joining us once again tonight in this room 592. Let me thank Josh, Kevin, Raj, and the entire team working hard behind the scenes. Thank Glenn Lal for making this program time freely available to us to have this done. And of course, my gracious co-host, Mr. Leonard Gildarie. Ladies and gentlemen, it's been good to have you, Marcia. Thank you so much, Siand. Thank you so much. Have a great night. And remember, say a prayer for this beautiful country of ours. It is still the best country in the world. Bye-bye now. Have a great night.
COVID-19 tips sponsored by Deck Soap. 1. Practice social distancing. 2. Wear your mask when leaving the house. 3. Wash your hands regularly for 20 seconds using our Deck Soap. 4. Cover your nose and mouth with a disposable tissue or flex elbow when you cough or sneeze. Choose Deck Soap for that extra cleanliness. Deck Soap is affordable and available nationwide.